Welcome to the Binary Agora. I'm your host, Alba Rivera Martinez, and today we're going to be commenting on a recent ruling issued by the Court of Justice of the European Union relating to the rights of news publishers to receive fair compensation for content used on online large platforms. So you'll maybe remember that we already went through this topic from the perspective of the DMA with Gozia Kozak, and now we're going to do it from the perspective of intellectual property. Thanks must first go to a friend of the show, Francisco de Abreu Duarte, for recommending Eleonora Rosati's nuanced approach on the media victory against social media, which is available in the IPCAT blog, and I'll also include the post below in comments. Eleonora is a professor of intellectual property law and co-director of the LLM in European IP at Stockholm University, and she's also an of-counsel at Bird & Bird. And for IP neophytes, I would very much recommend her book, published by Oxford University Press, Copyright and the Court of Justice of the European Union. Welcome to the Agora, Eleonora.
Thank you so much, Alba, for having me. It's a pleasure to be part of the show.
First of all, Eleonora, I wanted that you could excuse all of us who are not so immersed in the IP world, and maybe you could walk us through the legal questions arising from the case and why the ruling is important in this particular context.
The judgment stemmed from a referral from a preliminary ruling from the TAR Lazio in Italy, and it specifically concerned the compatibility of the Italian transposition of Article 15 of the 2019 DSM Directive with EU law. In order to unpack the relevance of this ruling, I think that I can start by saying a couple of words of this EU law provision. In essence, Article 15 introduced into EU law a new related right for the benefit of press publishers established in the European Union and for the use of their press publication by information society service providers. In a nutshell, this EU provision stems from past unsuccessful experiments at the national level, specifically in Germany and in Spain. These member states' experiences demonstrate the need for EU intervention. The provision during its the legislative process went through a number of changes, also because it appeared to be one of the most contentious provisions in the directive, and ultimately it had the shape that everyone can find in the directive. What happened after the directive was adopted was an echo of past experiences. Here I will go back to Germany, which introduced a related right for press publishers in 2013. But the reason why that German experience was unsuccessful is due to the fact that the law did not specify if the right could be waived or not. And the very day that the German law entered into force, so this is pre-directive, some of the addressees of this law announced that they would become opt-in, no longer opt-out. So if you wanted to be indexed by, say, Google News, you will need to waive your right to remuneration. Fast forward to 21, so nearly 10 years later, France was the first member state to transpose the new EU-related right, and also for the French transposition, nothing was specified regarding the waivability of the right. It felt like a déjà vu that indeed what happened in Germany a few years prior appeared at risk of happening again in France. Things were different for France because the local antitrust authority stepped in, and since then there have been many involvements of this competition authority. Then Italy, conscious of the experiences of Germany pre-directive and France post-directive, thought about having a transposition model that would avoid these kind of issues. Italy and then subsequently other member states transposed Article 15 in the sense of envisaging a potential involvement of the Italian Communication Authority AGCOM in the event that no deal could be struck between press publishers and information society service providers. AGCOM was tasked with this role in the management of the right and setting the amount of the fair compensation, equo compenso, due to press publishers. To this end, AGCOM adopted a regulation which sets the criteria for the determination of this amount. In essence, litigation has ensued in Italy regarding the compatibility with EU law of the Italian model, and Meta challenged the appropriateness of the Italian choice, with the result that the case is currently pending before administrative courts and a referral was made to the Court of Justice. The case is important because it is about the freedom of member states in transposing the directive, the involvement of a public authority in the negotiation of a private right, and also the fact that Italy is by no means an isolated instance, and there is another case currently pending before the Court of Justice, Streams. It is a referral from the Belgian Constitutional Court, which is asking several questions, including some that overlap with the Meta referral. Last but not least, when the case reached Luxembourg, it was sent to the Grand Chamber of the Court of Justice. So this shows, if nothing else, the importance of this referral, which goes, I think, well beyond the questions relating to the press publishers' neighboring right.
As you said, so the press publishers' right was introduced partly in response to these national experiments in Germany and also in Spain that had sought to tackle these declining revenues in the press sector and also what you call the substitution effect caused by news aggregators with not much success. For a reader who does not really follow IP law, can you explain in plain terms what this right is actually trying to do and whether it has delivered on that promise?
In essence, the initial target of this right were news aggregation services like Google News. The argument on the side of press publishers was exactly what you've mentioned, this substitution effect, that is, that users will be looking for news content using these services, and since they will get an aggregated list of links that will provide information that will be complete enough for them to get a sense of the type of information they want to acquire, users will not click on the link, with the result that monetization on the side of press publishers' websites will suffer. That was the idea around it. And of course, today it is not just about news aggregation services, but it is a right that targets potentially many other types of information society services. In the case of Meta, of course, Facebook, Instagram, and the question whether these platforms do actually use press publishers' content when they host and promote the content posted by users of their service, not posted necessarily by Meta itself. Same thing happens in other situations in which there might be another substitution effect. Other platforms, but also the incorporation of many AI models into search engines. Think of Gemini. Perhaps this is another upgrade of the related right, and this issue of declining revenues in the press sector, which is not necessarily something connected to the advent of the internet. According to some studies, it began with the introduction of television, but that certainly over the past several years has become increasingly problematic.
Actually, the initial reaction from some of the commentators following this Court of Justice's ruling was that it strengthens the position of the media sector vis-a-vis big tech companies as the ones you were mentioning now. And I believe that you push back a bit on that narrative and I wanted to ask you, what did the Court of Justice's ruling transform, and how is that going to impact in the future on news publishers?
The outcome of the referral is, on the face of it, in favor of press publishers, because the Court of Justice refrains from ruling the Italian model incompatible per se with EU law, so that is objectively good news. It also recognizes that the goals pursued by the Italian legislature were in the sense of strengthening the bargaining position of press publishers. At the same time, however, the Court of Justice also adds some nuances that I don't think can be underestimated. Amongst them, there is the fact that the CJEU says that the right can target information society service providers that do not use press content. So this is a question of fact, but it is a key question, because the right is only enforceable against those information society service providers that use press content, and among the exclusions to protection, there is what individual users do in a private capacity. So it is all about defining the border between what is and what is not within the scope of the right. Then, of course, the Court of Justice also mentioned another key aspect, that is the fact that exclusive rights must remain such. So it is not possible to turn exclusive rights, including those of press publishers, into mere entitlements to remuneration. It will now be for the TAR Lazio to make a determination whether that is in fact what the Italian model does do by foreseeing the involvement of AGCOM in determining the fair compensation.
I was wondering, so how broad is this concept of press content within the directive?
The directive does provide quite clear guidance regarding what a press publication is, and so that is certainly much more certain than other concepts that are found in the directive. But I think that here it is all about determining whether there is use or not, and that is a concept that is not defined in the directive. It will need to be construed in accordance with the guidance that the Court of Justice has provided in other situations in which no such definition is given. And of course, a natural parallel that comes to mind is the one with internet platforms and whether they use content posted by their users. In the directive, there is another provision, Article 17, that posits a direct responsibility of online content sharing service providers, as the directive calls them, for user-uploaded content. But this is not a clarification of the law. It is a change in the law, because the Court of Justice, in another ruling that was issued in 2021 concerning YouTube and a cyber locker, under the pre-existing law, came to the conclusion that you need to consider a number of criteria to determine if there is in fact use on the side of internet platforms when it comes to content that users of such platforms do upload and publish.
As you were saying, the Grand Chamber confirmed that the Italian model may be compatible with EU law, but also added that exclusive rights like those of press publishers cannot be turned into mere entitlements to remuneration, and that the right only applies where platforms are actually using those press publications themselves and not simply hosting content uploaded by users. On this last point, what kinds of platforms are genuinely in this gray zone, and how much litigation do you anticipate to be generated in this area?
It is difficult to give an answer because this provision was drafted with news aggregation services in mind. And that is, I think, a common issue that emerges when you draft the law, bearing in mind a specific technological situation. Now I will say that anyone who is not a news aggregator service in the classical sense may be questioning whether in fact they are using content that others have posted, and specifically users of their services.
You also point out in the post that the Court of Justice's ruling undermines proposals that would allow AI training to proceed without the right holder's consent? How can we draw a line between the world of news publishers remunerated for their content and the looming risks posed by AI, notably, for instance, the use of content by Google's own search engine via AI overviews?
The Court of Justice does strengthen right holders' positions by being adamant that, as I was mentioning, exclusive rights are such. So over the past few years, there have been some mostly academic proposals in the sense of envisaging a remuneration model for authors and right holders, which would essentially deprive them of the possibility to authorize or deny use of their content and instead be receiving a piece of the cake post-training. I think that the Court of Justice, by adopting this clear stance on the nature of exclusive rights, which, by the way, is not the first time that the Court of Justice does that, I think has removed the possibility of considering these proposals feasible, at least insofar as Europe is concerned. In essence, when it comes to AI training done on protected content, and by that I mean content protected by copyright and related rights, either you have the right holder's consent or you are able to invoke successfully an exception that spares you from doing that. And here we can open an entire new chapter whether there is in fact an exception or a combination of exceptions that would allow to cover the entirety of AI training.
That's really, really interesting because, as you may know, we already have this case in with the European Commission triggering proceedings under Article 102 with regards to how Google trains this data and trains its search engine and the features it provides to users via the content that it already processes of web publishers and editors. So it's really interesting to have this other side of the coin view. And thank you so much, Eleonora, for all of your discussion, your thoughts, your insights.
Thank you so much. It's been a pleasure being part of the program, and I look forward to seeing indeed how things unfold and continue this discussion. Thanks so much for having me.
Thank you so much, Eleonora. Bye-bye.